So today, we had two cases end. Two cases ended today. The Arbery case ended because the defense's theory of the case was wrong on the law.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state.
My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. So the Arbery case comes down to one key question. Were the McMichaels conducting a lawful citizen's arrest? See, when they were attempting to detain Mr. Arbery, they needed a reason, a legal reason, why they can detain another citizen and deprive him of his rights. So the defense's theory of the case has always been simple. They were trying to conduct a citizen's arrest, a lawful citizen's arrest. You're looking at the arrest by person statute. Now, this is actually a defense exhibit from their opening statements. Now, the first sentence is clear. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. Then there's a second sentence, which is highlighted here, that says if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So now the defense's argument is that, hey, that first section doesn't apply to them, right? It doesn't apply. What does apply is this second section. Here is the defense attorney explaining the defense's theory of the case.
Second sentence the state didn't tell you about. The second sentence is, if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. That's why Travis McMichael and Greg McMichael sought to detain him at Arbery. There was no crime committed in their presence. We're not contending there was a crime committed in their presence, but there was probable cause to believe a felony had been committed and that this man was attempting to escape or flee. That's why citizen's arrest is in this case.
Now, as you can see, the defense attorney is making it very clear that they can see the first part of the statute. This didn't happen in their presence, and they didn't have any immediate knowledge of it. Their sole argument for the lawfulness of their citizen's arrest is based on this second sentence. But now, the judge has to now charge the jury through jury instructions. So, does the judge just say, okay, the second part of the statute applies and the first part doesn't? Or do both apply? Well, here's what the judge had to say about it.
Tell you how the court's going to charge this. I don't read the statute the same way as the defense. I read into the statute. The first line addresses both felonies and misdemeanors. The second sentence narrows that then down to felonies. It doesn't discount misdemeanors. It just says in the case of felonies, if there's an escape going on, then the arrest can be effectuated. The way I read that is if it's a misdemeanor, the guy can be arrested, gal, whoever it is, can be arrested by whoever is effectuating the citizen's arrest. But if they run, then you can't go chasing after misdemeanors. In the case of a felony, you can. And a person who is chasing somebody who's escaping on a felony that is justified upon reasonable and probable grounds for suspicion can effectuate the arrest. So the charge that I am going to provide, I'm going to amend a little bit from the state's language, and that is that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during the escape. If the observer fails to make an arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. I'm not going to comment on the legality or illegality, so I'm putting a period at the end of extinguished and removing the and a subsequent arrest is illegal. So, again, private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during escape.
I'm sorry, could you say that last portion again? Or in the
case of a felony, during escape. If the offender fails to make the arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. That's what the court intends to charge. I understand there's an exception from the defendants.
So both parts of the statute have to be fulfilled to have a lawful citizen's arrest. And the defense knows that charging the jury that they have to satisfy both parts of the statute essentially loses their case because they've just conceded earlier that they didn't conform with the first part of the statute. Remember, it didn't happen in their presence.
There was no crime committed in their presence. We're not contending there was a crime committed in their presence, but there was probable cause to believe a felony had been committed and that this man was attempting to escape or flee.
So that concession earlier, that they were only applying to part two, has now essentially lost them the case. And here's the defense attorneys arguing that point.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state. You are rendering the second sentence in which it describes reasonable and probable grounds of suspicion meaningless. It's in there presumably for a purpose. It's a different burden than immediate knowledge or presence. And so I would urge the court to reconsider and eliminate this, let the state argue what they're going to argue. We have built this whole case around the probable cause, the second sentence, last phrase that Travis McMichael and Greg McMichael had on February 23rd for events that happened previously. And you are gutting all of it if you give this particular charge.
May I ask, Your Honor, if, I know we're Friday at 2:30, if over the weekend we were able to email to you or your staff a full, complete with citations argument for what position we're arguing for here, that this contemporaneity of the offense for which you are fleeing and being chased.
Why don't we do this? This is what I intend to charge. I'm not going to reopen all of the charges. I understand the significance of the charge that is presented. I will, if I'm provided something, at least on a timely basis over the weekend, where I can digest and the state then have an opportunity to digest and respond. This charge, I will remain, the intent is as I've described. But if I'm provided different authority than I've already been provided, I will go ahead and reconsider upon the presentation of any additional authority that may come.
Could I shoot for, say, midday tomorrow? I'll be working on it all morning, tonight in the morning, not Sunday, but sometime tomorrow, get it to the court. And
That's fine.
And at some point, whatever other email addresses you'd like me to use, I'll use. I may have them all already.
Yeah, I think you've got just about everyone we've got.
Okay.
I can't think of any more that hasn't been provided.
Your Honor, I think I've already submitted all the law that I can find, but we'll certainly be happy to adopt what more learned co-counsel can submit. But I agree with Mr. Rubin. And I'm not saying that it's the intention of the court. I don't want to be misunderstood. But the practical effect of this charge is a directed verdict of guilt. And it's a denial of the sole defense of at least 2, if not 3, of the defendants in this case. I mean, I think the court's indicated the court appreciates the gravity of the charge, but I'm just joining in that because that's just the way it is.
So in the Kyle Rittenhouse case, his justice came from a jury. But in this case, it seems like Arbery's case, justice came from the judge. So what do you think? Do you think they got any type of shot? Do you think they should take a deal? Because the jury is charged like this judge intends to charge them. Game over.